Hello, hello. Hi. We're back. Happy Monday. What is going on? Feels good to be back talking about true crime. Yay! Lily made it on time. Yay. What's up, Lily? I saw 𝗃𝐶𝐶. I saw being bio girl. Hello. I'm glad you made it, Lily. Thank you guys for being here. I saw Stain too. Hello. We're going back to Gabby Petito. We're going to cover the lawsuit her parents filed against the Laundries. It's not too long, but welcome. I hope you guys had a good weekend. I definitely did. A lot going on. But for this live, we're going to be talking true crime. So again, I always say this at the beginning. My heart goes out to the Petito family. They're amazing. And everything we're reading here is court paperwork, but my opinion is just my opinion. So make of it your opinion what you will. Make sure you subscribe, do all the YouTube things. Yay, be my guy. I know I missed being live. I was like, I generally go live a lot during the weekend, but there's a lot going on. So we do have another live after this, so we can talk more there about that stuff. But let's get this Gabby Petito stuff. Let's read through this document. We've been deep diving the Gabby Petito case. I got all the files, so we've read quite a few. This is probably the fourth live that we do on the documents. So tonight we're just going to read their statements, the parents, and then we're going to read through the complaints, like 9 pages. It's not too long. But first, I wanted to touch on this missing little baby. He's been all over YouTube today, but I wanted to make sure that I showed his missing poster. Hey, Killiswag, you can't with Casey, right? This is Dane Paulson, and it's he's missing. The Lincoln Sheriff's County Office is searching for a missing 2-year-old child. Dane Paulson was last seen in the yard of 2073 Silitz Highway at approximately 4:30 p.m. on Saturday, March 1st, 2025 in Silitz, Oregon. Dane was last seen wearing a dark gray fuzzy hoodie, black pants, and blue and white shoes. Dane has brown hair that is shaved on the sides and long on the top. The sheriff's office has also listed a late 90s gold-colored station wagon as a vehicle of interest. A vehicle matching this description was last seen in the area before Dane went missing. The sheriff's office is requesting anyone who may have information relating to Dane's disappearance or information relating to a vehicle matching this description to call their tip line. So I did just want to bring this to everyone's attention because I first heard about it from one of my mods, but I've seen a lot of people make videos on it today. So let's hope that baby Dane gets found. I'm horrified. I'm worried about him. He's only 2 years old. So yes, I am okay. It's good to see you guys. I'm doing great. Yeah, I just took the weekend off, just stuff. Hey, Crazy, I'm glad you made it. Yay, Casey here. Okay, let's get it moving. We're gonna cover, I'll say. We have another live after this, so I hope you guys can make it to that too. You know how that goes. I was saying you were early, but you're late, so I'll let it go this time. Just kidding. Okay, let's see. We're going to read 1-page statements from the family and the Laundries and the Petito family. Let me make sure you guys can see this. My bad. Hold on. Let me fix that. My bad. I should have had that, but I had the missing poster set up. Don't come for me. Okay, let me see. We have lots to talk about tonight. We do. I'm sure you all have questions. Huh? So it's even out to be it evens out. Yeah. Hey, Berrywood, good to see you. Okay, let's see. It kind of sucks you can see it all, but whatever. Good to see you. Thank you for being here. I appreciate it. Okay, so the first one is statement from filed September 14th. No, let me see. Is that too zoomed in? No, that's perfect. Oh, I bet. September 14, 2021, regarding Ms. Petito. This is the statement from counsel for the Laundrie family. It says, this is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. On the advice of counsel of the Laundrie family is remaining in the background at this juncture and will have no further comment. The 𝐁𝐮𝐲 and Petito family are going through the worst moments of their lives. Their beautiful 22-year-old daughter is missing, and that one person that can help find Gabby refuses to help them. Brian Laundrie was traveling with, let me make sure that I'm not skipping pages. Yeah. Brian Laundrie was traveling with Gabby in the Grand Teton Yellowstone area. They were traveling together in Gabby's 2012 Ford Transit van. This is where we believe Gabby was last seen. Brian is refusing to tell Gabby's family where he last saw her. Brian is also refusing to explain why he left Gabby alone and drove her van to Florida. These are critical questions that require immediate answers. The 𝐁𝐮𝐲 and Petito family begged the Laundrie family to not remain in the background, but to help find Brian, who referred to her as the love of his life. How does Brian stay in the background when he's the one person that knows where Gabby is located? The 𝐁𝐮𝐲 and Petito family implore Brian to come forward and at least tell us if we are looking in the right area. And then this statement is to Christopher and Roberta Laundrie. It says, we are writing you this letter to help find our beautiful daughter. We understand you're going through a difficult time and your instinct to protect your son is strong. We ask that you put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how could you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family has any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen. And all of Gabby's parents and step-parents signed this letter. It's so sad. I know. I know. I know, it is so sad. What up, prison guard? Hey. It's terrible. Let's move on to the complaint. Petito and 𝐁𝐮𝐲 versus Laundrie, the Laundries. This is the lawsuit the complaint. Come now, Joseph and Nicole 𝐁𝐮𝐲 by and through undersigned counsel complaint against the Laundries. This action for damages. Venue is in Sarasota County. The plaintiff, Joseph Petito, is from Florida. He's the father of Gabby Petito. Nicole 𝐁𝐮𝐲 is resident of New York. Mother, Christopher and Roberta Laundrie are the parents of Brian Laundrie. We know that. Brian and Gabby became engaged to marry on or about July 2nd, 2020. On July 2nd, 2021, Brian Laundrie and Gabby Petito left New York in a van owned by Gabby Petito to take a trip to the Western United States, which was expected to last for several months. Prior to the trip taken by Gabby and Brian, Joseph and Nicole, Christopher, Roberta had a cordial relationship. Gabby had hopes of becoming a traveler influencer, a van lifer, and document her cross-country travels on social media such as YouTube, Instagram, and TikTok. During the course of the aforementioned trip, Gabby called her family almost daily, including her parents, Joseph and Nicole, and her siblings. The last communication that Gabby had with Joseph was on August 21st, 2021. The last communication that Nicole 𝐁𝐮𝐲 had with Gabby was on August 27th, 2021. It is believed that on August 27, 2021, Brian Laundrie unalived Gabby, and the cause of her death was blunt force injuries to the neck and head with manual strangulation. Gabby was 22 years at the time of her death. I know, it's so heartbreaking. I agree. After Brian Laundrie murdered Gabby, Brian Laundrie sent text messages back and forth between his cell phone and Gabby's cell phone in an effort to hide the fact that she was deceased. On August 27, 2021, it is believed that Brian sent a text to Nicole in which he referred to Gabby's grandfather, Stan, by name. Gabby never called her grandfather by his name. It is believed and therefore averred that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher and Roberta, that he had unalived Gabby Petito. On that same date, Christopher and Roberta spoke with attorney 𝗟𝗶𝗸𝗲 and sent him a retainer on September 2nd, 2021. On August 30th, 2021, Brian sent a text message from Gabby's phone to Nicole stating that there was no service in Yosemite Park in an effort to deceive Nicole into believing that Gabby was still alive. On September 1st, 2021, Brian returned to the home of his parents, Christopher and Roberta, driving Gabby Petito's van. After this point in time, there was no contact between Joseph and Nicole on the one hand and Christopher, Laundrie, and Roberta on the other. From August 27th, 2021 until September 19th, when Gabby Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabby. While Gabby's family was suffering, the Laundrie family went on vacation to Fort DeSoto Park on September 6th through the 7th. In an effort to avoid any contact with Nicole Schmidt on or about September 10th, Roberta blocked Nicole on her cellular phone such that neither calls nor texts could be delivered, and she blocked her on Facebook. I remember that being wild, the whole blocking. Hey, Loki Lopez, good to see you. That's wild. An effort to avoid, oh yeah, I already said that. She blocked her on Facebook. On September 14, 2021, with full knowledge that Gabby had been unalived by their son, Christopher and Roberta, through their lawyer, issued the following statement. It is our understanding that a search has been organized for Ms. Petito in or around Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. On September 16, 2021, attorney Richard Stafford, on behalf of Gabby Petito families, issued a letter to Christopher and Roberta Laundrie as follows. We are writing you this letter to ask you to help find our beautiful daughter. We understand you're going through a difficult time. This was part of the part that we read earlier. To protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, tell us where Gabby is located. Tell us even if we're looking in the right place. All we want is Gabby to come home. Please make that happen. Despite the fact that Joseph and Nicole implored Christopher and Roberta to tell them if their daughter was alive and if she was not, where her remains were located, Christopher and Roberta refused to respond to either of Joseph's or Nicole's or law enforcement. Christopher and Roberta instructed that all contacts were to be made through their attorney, Stephen Bertolino, and issued a no comment when asked about Gabby's well-being. While Joseph and Nicole were desperately searching for the information concerning their daughter, Christopher Laundrie and Roberta Laundrie were keeping the whereabouts of Brian secret, and it is believed were making arrangements for him to leave the country. Hey, Knight, what's up? Good to see you. The parents, they're his own parents. I said that in the other live, like, would your parents cover for you if you unalived someone? I'm just curious. That's crazy. Leave the country? I didn't know that part. Yeah, I didn't know what you guys were talking about either with the baskets. Okay, let's move on. Christopher and Roberta knew of the mental suffering and anguish of Joseph and Nicole and knew that they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well-being and the location and remains of Gabby, yet they repeatedly refused to do so. In doing so, Christopher and Roberta acted with malice or great indifference to the rights of Joseph and Nicole. Christopher and Roberta exhibited extreme and outrageous conduct, which constitutes behavior under the circumstances which goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. As a direct and proximate result of the willfulness and maliciousness of Christopher and Roberta, Joseph and Nicole have been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for enjoyment of life, experienced in the past to be experienced in the future. Wherefore, plaintiff Joseph and Nicole respectfully request this honorable court enter judgment in their favor against the defendants, Christopher and Roberta Laundrie, and award them the compensation for the damages they have suffered together with the cost and such other relief as this honorable court deems just and appropriate. This next document return of service. This is just the court files. Here comes the judge on the 14th day of March 22 to be served. Christopher Laundrie, personally serving by delivering a true copy of the summons complaint. Oh, this is just that they got served with it. The proof. Summons for Christopher Laundrie. These are always interesting to look at, I think. All this court paperwork. We're going to read the response to the complaint, but we're going to get through the summons first. There's another summons. This one's for Roberta Laundrie. Yeah, Roberta Laundrie. They're shady. The Laundries. What is this? Let's see. Plaintiff's notice of service or first set of interrogatories to defendant Christopher Laundrie. Plaintiff's first request for production to defendant Christopher Laundrie. Oh, this is interesting. To produce original or legible copy of the things enumerated, basically turn everything into their lawyers. I kind of read through this part earlier, and it just talks about how their phones were seized, the parents, their computers, the text messages, all the conversations. They had to investigate all of that, the metadata. All telephone bills, both cellular and residential, from August 2021 to November 2021. Christopher, Roberta, Brian, and Gabby. All telephone bills, financial documents, all correspondence. Okay, here we go. We're going to read the Laundrie's response to. Make sure that's going to let me zoom in. I might have to put it on another screen. Hey, Michelle, good to see you. Oh, I'm sorry. Let me put that back up. It's good to see you, Michelle. Thanks for being here. Let me see. I'm trying to zoom this in. It's not letting me, so I might have to download it real quick. I don't know why that's being. Oh, there we go. Can you see that? Defendant's motion to dismiss the complaint against the Petitos. I can't believe they still lied about their daughter, and then they do everything to fight the civil lawsuit. How sad, right? My heart goes out to the Petito family. I still haven't watched the documentary, but I'm definitely wanting to. And he doesn't like anyone to talk to him. Right. Hey, number 7, good to see you. Okay, let's see. Defendants to dismiss complaint. Christopher and Roberta Laundrie hereby move to dismiss the complaint filed against them by the Petitos. The background is the facts surrounding this case have received widespread media and attention, and the court is likely at least generally aware of the events that precede the filing of the lawsuit. The complaint alleges that the plaintiff's daughter, Gabby Petito, and the defendant's son, Brian, were engaged to be married. Ms. Petito and Mr. Laundrie were traveling the Western United States in the summer of 2021. At some point during their trip, Ms. Petito went missing, and there was a search for her whereabouts. Shortly thereafter, law enforcement commenced an investigation which included Brian Laundrie and the defendants. The complaint does not allege when Ms. Petito was reported missing or when the law enforcement investigation of the Laundries began, but news reports indicate that Ms. Schmidt reported Ms. Petito missing to the Suffolk County Police Department on September 11, 2021. Ms. Petito was found deceased in Wyoming on September 19, 2021. Brian was later found deceased in Florida on October 20th of suspected unaliving himself. The complaint should be dismissed with prejudice, and the plaintiff should not be granted leave to amend. Although leave of court to amend a pleading shall be given freely when justice so requires, Florida Civil Code leave to need not given where the amendment be futile. A proposed amendment is futile if the insufficiently pled or insufficient as a matter of law, or is insufficient. The complaint is insufficient and deficient as a matter of law for many reasons, and those deficiencies cannot be cured by an amended complaint. The gravamen of the claimed wrongdoing is that the Laundries exercised their constitutional rights and essentially made no statements to plaintiffs or law enforcement. As a matter of fact, the Laundries' silence could not form the basis of a claim for intentional infliction of emotional distress. The Laundries' constitutional rights and the elements necessary for such a cause of action would not change with an amendment of the complaint. Furthermore, the time period at issue occurred several months ago, and the foundation of the plaintiff's claim distress wanting to find their daughter has been resolved. There are no more facts that could emerge that would bolster the plaintiff's claim. The plaintiff's failure to state a cause of action in the complaint provides ample basis to conclude that the plaintiff should not be able to add the missing but required information if provided with another opportunity to bolster their allegations. As an amendment to the complaint would be futile, the complaint should be dismissed with prejudice. The plaintiff's allegations attempt to set forth a cause of action for intentional infliction of emotional distress. As an initial matter, the complaint's ambiguity and the lack of separate segments and counts as to each plaintiff defendant pursuant to 1.100 independently warrants dismissal for repleading. The allegations must be sufficient to form the defendant of the nature of the cause against him. The defendants assume the cause of action is one for intentional infliction of emotional distress because the words relevant to the elements of that cause of action appear in the complaint. However, the phrase intentional infliction of emotional distress appears nowhere in the complaint. It is also possible that the plaintiffs might be trying to allege a cause of action for tortious interference with a dead body, but it is not at all clear. Florida rule procedure requires that a complaint must state a cause of action, and if a complaint is so vague, indefinite, and ambiguous as to wholly fail to a state of cause of action, it is subject to dismissal. Plaintiff's complaint ambiguously draws language from two unidentified causes of action and does not identify either as a cause of action upon which it relies. That deficiency requires dismissal. The complaint is further deficient because it names two plaintiffs and the defendants without attempting to distinguish between them. The complaint offers no theory that would impute the conduct of one of the defendants against another, so any cause of action against them must be separate. The same is true of the plaintiff's individual cause of action. Commingling various claims against all defendants together may warrant dismissal of a complaint. Similarly, each distinct plaintiff must maintain its own action to recover for its own loss. While these two pleading deficiencies require dismissal and could be potentially corrected by amendment, plaintiffs' legal theories are fatally flawed and could never be remedied by an amendment, thereby requiring dismissal of the complaint with prejudice. The complaint fails to meet factual pleading requirements. Pleadings must be something more than an ingenuous academic exercise. Florida is a fact pleading jurisdiction. To withstand dismissal, a plaintiff must allege more than a naked legal conclusion. It is insufficient to plead opinions, theories, legal conclusions, or argument. The quality of pleading that is acceptable in federal court and which will routinely survive a motion to dismiss for failure to state the claim upon which relief may be granted will commonly not approach the minimum pleading threshold. Florida officially recognized the tort of intention infliction of emotional distress in 𝐁𝐿 case, which adopted restatement. To state a cause of action, a complaint must allege 4 elements: deliberate or reckless infliction of mental suffering, outrageous conduct, the conduct caused the emotional distress, and the distress was severe. Yeah, I agree that the Laundries did. I mean, we saw the video of them, the police coming to their door. They lied about everything. The letter, burn after reading. Hey, Michelle, good to see you. That's definitely emotional distress, in my opinion. In applying to the standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intention infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Even if a complaint alleges the facts, if proved, must establish a cause of action for which relief may be granted. While the plaintiffs allege some facts, those facts could never establish a claim for intentional infliction of emotional distress because the Laundrie's actions were legally permissible, constitutionally protected, not outrageous, and do not give rise to any cause of action. Outrageousness is the threshold test for recovery in an intentional infliction of emotional distress claim. Whether the conduct is outrageous enough to support such a claim is a question of law, not a question of fact. Importantly, the standard for outrageous conduct is particularly high in Florida. It is not enough that the defendant acted with an intent, which is tortious or even criminal, or that the defendant intended to inflict emotional distress, or even the defendant's conduct can be characterized by malice or a degree of aggravation, which would entitle the plaintiff to punitive damages for another tort. Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and be regarded as atrocious and utterly intolerable in a civilized community. Generally, the case is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor. The law is clear that pleading is insufficient if it contains merely conclusions, as opposed to ultimate facts supporting each element of the cause of action. Although the complaint alleges the Laundrie's conduct was outrageous, the complaint's failure to provide factual support rising to the level of outrageous conduct makes the allegation nothing more than a legal conclusion. The essential allegations against the defendant are nowhere close to meeting the necessary standard. Those allegations are, without providing any factual support, the complaint states that Brian Laundrie told his parents that he unalived Gabby Petito. Christopher and Roberta Laundrie spoke to and hired an attorney on September 2nd. After September 1st, there was no contact between the Laundries and Joseph and Nicole Schmidt. The Laundries went on vacation to Fort DeSoto Park from September 6th through the 7th. Roberta Laundrie blocked Nicole on her cell phone and Facebook on September 10th. The Laundries' attorney made a statement on September 14th. The attorney for Joseph Petito and Nicole issued a letter to the Laundries on September 16th. The Laundries did not respond to Joseph Petito, Nicole, or law enforcement. The Laundries instructed that all contacts be made through their attorney, who did not comment. The Laundries did not provide the whereabouts of Brian, followed by the unsupported allegation that the Laundries were making arrangements for Brian to leave the country, which is contradicted by the undisputed fact that Brian Laundrie was deceased. Complaint, and the Laundries could have alleviated the mental suffering of the plaintiffs by disclosing what they knew about Gabby's location. Although the complaint makes several accusations about Brian Laundrie's conduct, he is not the defendant in this case, nor is there any legal theory that could impute his conduct to his parents. None of these allegations recited above, either alone or together, describe outrageous conduct. In fact, the complaint fails to allege conduct at all. Basically, the complaint alleges that the Laundries failed to have any contact with the plaintiffs when the plaintiffs wanted them to speak. That allegation falls so far below the particularly high standard for outrageous conduct that the complaint should never have been filed. The only affirmative statements alleged in the complaint were made by the attorney for the Laundries, which is entirely appropriate under the circumstance. Conduct claimed to cause such emotional distress must be so outrageous in character and so extreme in degree as to go above and beyond all possible bounds of decency. The Laundries' decision to exercise their constitutional rights to silence, privacy, and counsel, and to have their attorney speak for them under such trying circumstances and media pressure could not be further from conduct that is extreme or goes beyond all bounds of decency. It is what most people would do and should do in a situation and in a civilized community. The letter by the plaintiff's attorney referenced in the complaint even acknowledges the complicated conditions faced by the Laundries. We understand you're going through a difficult time and your instinct to protect your son is strong. The plaintiffs cannot express sympathy and understanding for the Laundries' inevitable position and then claim the Laundries caused them emotional distress by not responding in the way plaintiffs desired. If the Laundries' act of doing nothing other than maintaining their privacy and silence is enough to subject them to the supposed cause of action, then there would be virtually no limitations on the tort of intentional infliction of emotional distress, and the fundamental right to remain silent under any circumstances would be obliterated. I mean, I don't blame them for wanting to stay quiet. I mean, I would probably want to do the same too, but this is different, right? They were family. Where's Gabby? It's terrible. Labeling the Laundrie silence as outrageous is particularly incongruous with the context of attempt to contact the Laundries discussed in the complaint. The only attempt at contact alleged is the attorney for the plaintiffs issued a letter to Christopher and Roberta Laundrie asking for their help in locating Gabby, because it would be a violation of Rule 442, the rules regulating the Florida bar, for the plaintiff's attorney to contact the Laundries, knowing the Laundries were represented by an attorney at the time. The plaintiff's attorney presumably did not send the letter directly to the Laundries. The complaint is not specific about how the letter was issued, whether through the mail or some other means. The complaint says nothing about whether the Laundries actually received that letter, so their lack of response is a far cry from outrageous conduct that goes beyond all bounds of decency. Furthermore, that the Laundries would not respond to a communication that may or may not have violated rules of professional conduct is hardly outrageous. Furthermore, the intent element alleged is insufficient as a matter of law. The complaint accuses the Laundries of acting with malice or great indifference to the right of plaintiffs. However, the Florida law is clear that acting with malice or indifference is not enough. Outrageous conduct is what is required, and the plaintiffs have not alleged it. Even if the court were to have reservations as to whether the Laundries' silence was outrageous, to permit this claim to move forward would trample the Laundries' constitutional rights. As discussed below, the Laundries' conduct was legally protected and cannot form the basis for an intentional infliction of emotional distress claim. This infuriates me so much. At its core, the complaint is critical of the Laundries for refusing to respond to either Joseph and Nicole or law enforcement. However, compelling individuals to respond to inquiries by private citizens or law enforcement through a civil action like this would turn our entire constitutional system and the freedom afforded individuals in this country on its head. The plaintiff's suit, founded on their thoughts or positions or what they wanted the Laundries to do, infringes on too many fundamental rights, all to be discussed in the motion, but the exercise of even one right is sufficient to defeat a claim for intentional infliction of emotional distress. From the first recognition of the tort of infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would be extreme and outrageous, may be privileged under circumstances. The actor is never liable, for example, where he has done no more than to assist upon his legal rights in a permissible way, even though he is well aware that such instance is certain to cause emotional distress. That's bull. The Laundries had a legal right to do or not to do everything described in the complaint. The Laundries are entitled to the right of freedom and of thought protected by the First Amendment, which includes both the right to speak freely and the right to refrain from speaking at all. The right to speak and the right to refrain from speaking are complementary components of the broader concept of an individual freedom of mind. The clear implications has been that any such compulsion to publish that which reasons tells them should not be published is unconstitutional. The Laundries have a general constitutional right not to speak on any topic and a more specific constitutional right not to speak in the face of a criminal investigation. There was unquestionably a law enforcement investigation of the Laundries regarding the disappearance of Miss Petito, and the Laundries had and still have an absolute right to remain silent. For the Laundries to exercise their constitutional right to refrain from speaking and to instead hire an attorney to speak for them is not only common practice in a civilized community, but it embodies the exercise of fundamental rights under the United States and Florida constitutions. Both the United States Constitution and Florida Constitution indisputably permit retention of any attorney, and on any occasion they require the government to provide the services of an attorney. The citizen's right to consult an independent lawyer and to retain that lawyer to speak on his or her behalf as any aspect of liberty is priceless. Florida provides an even broader right to counsel than and is provided by the Sixth Amendment. In addition to the federal Sixth Amendment right to counsel, there's a long recognized First Amendment right to hire an attorney and consult an attorney. We know that, right? Along with the protection afforded by the First, Fifth, and Sixth Amendments to the United States Constitution and similar provisions in the Florida Constitution regarding speech and legal representations, the Laundries also have federal and state constitutionally protected privacy rights. The Due Clause of 14th Amendment protects individuals from the state intrusion on fundamental aspects of personal privacy. Put simply, the Laundries have fundamental constitutional rights to silence, privacy, and representation by counsel. The Laundries' exercise of these rights is what the plaintiffs claim caused their emotional distress. The Laundries' rights are inalienable, and the Laundries can never be liable for exercising their rights in a permissible way. Thus, as a matter of law, the plaintiffs have not alleged any act or conduct on the part of the Laundries that would impose liability upon them, which would survive a constitutional challenge. Hey, Laura, good to see you. I'm glad you made it. What's up? Let me hang up. They ended up, I believe, not getting what they wanted from this lawsuit too, the Petito family. That's upsetting. It's upsetting. The complaint suffers from another fatal flaw that is further evidence as to why there's no cause of action for the factual scenario. For conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and in his or her presence. As we set forth in the complaint, there was no contact between the Laundries and the plaintiffs after September 1st, 2021. If there was no contact, then the Laundries certainly could not have committed any act in the presence of the plaintiffs that would support of action for intentional infliction of emotional distress. What happened to Ms. Petito is certainly unfortunate. However, as the Third District Court of Appeal reasoned, quote unquote, if courts were to allow relatives of tort victims compensation for their distress they suffer when they receive bad news about family members, when there's no attendant intentional or reckless conduct directed toward them, an avalanche of litigation would ensue. Compensation is available for actual harm to the victim. Only in carefully prescribed circumstances is compensation permitted for relatives who suffer emotional distress. It is not a lack of compassion, but necessity that restricts relief to the immediate victim. The last two elements necessary to state a claim for intentional infliction of emotional distress require factually supported allegation that a defendant's conduct was outrageous and caused the victim emotional distress that is severe. The complaint alleges that the Laundries knew of the mental suffering and anguish of plaintiffs, and they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well-being and the location of the remains of Gabby. By setting forth that allegation, the plaintiffs acknowledged that their mental suffering and anguish existed prior to and independent of the Laundries' conduct of remaining silent. Rather than alleging the Laundries were the sole and proximate cause of the plaintiff's distress, in essence, the plaintiffs allege that the Laundries' silence failed to alleviate, at least in part, such mental suffering and anguish. Since alleviation can only come after the suffering is already being experienced, the Laundries' alleged failure to alleviate is not the sole and proximate or legal cause of the plaintiff's alleged injury. Stated differently, the complaint's own allegations contradict the theory that the Laundries caused the plaintiff's mental suffering and anguish. The complaint alleges that the Laundries were direct and proximate cause of the plaintiff's injury, and also alleges that the plaintiff's grief was caused by something other than the Laundries' silence, which means, as both matter of law and fact, the complaint fails to allege that the Laundries were the legal cause of the plaintiff's grief, and the complaint should be dismissed. The pleader is bound by his own allegations in the complaint, and courts are not bound by bare allegations, which are unsupported and unsupportable. In addition to the lack of support for the causation element, the complaint does not allege, let alone factually support, that the emotional distress was severe. The complaint spends most of its paragraphs discussing the Laundries and provides nothing beyond the conclusory allegation of mental suffering and anguish by the plaintiffs. The term severe does not appear as a description of the plaintiff's alleged injury. Where the elements of a cause of action are not pled, they may not be inferred from the context of the allegations. While the complaint alleges the plaintiffs were extremely distraught and desperately searching for information concerning the daughter, the complaint does not specifically discuss how the plaintiff's mental suffering meets the severity element, nor does it describe the distress as severe. The fact remains, however, that significant feelings of fright, shame, worry, and humiliation and others, besides occasioned by the acts of others, are, even if regrettable, an unavoidable part of living in society. Thus, courts that have tackled this issue have recognized that a high standard for determining what kind of emotional distress is remediable and in claim for intentional infliction is necessary to prevent the tort from becoming a venue for litigation over every emotional injury. In sum, the plaintiffs have failed to satisfy the elements of causation and severity. The plaintiffs were understandably fearful about what happened to their daughter, and they would have been upset about their daughter regardless of anything the Laundries could have said. But that fear or sadness was not caused by the Laundries. It was unfortunate, unavoidable part of the entire circumstances surrounding Brian and Gabby. Conclusion. The plaintiffs have not come and set forth assertions that can be supported by evidence which gives rise to legal liability. As such, the action for intentional infliction of emotional distress against the parents of Brian Laundrie, however inartfully drafted, is not legally sustainable, and the complaint should be dismissed with prejudice and without leave to amend for all of the reasons set forth. Whereas defendants Christopher and Roberta Laundrie respectfully request the court to dismiss the complaint with prejudice. I'm shook. Plaintiffs respond to defendant's motion to dismiss complaint. Hey, Irony, what's up? Her ex was devastated. Was he? Hey, Forging Thought, good to see you. Good to see some new faces, I think, here. Yeah. Was he in the documentary, The Ex-Boyfriend? I'm curious. Hi, Mike, Omara. I never knew he was so controlling. Yeah, we've covered a lot of it here. Reason I think that's what happened when you watch the story, Gabby reached out to her ex while Brian took a trip home. As soon as Brian returned, Gabby went missing. Yeah, I think the reaching out to the ex was a big deal. The Brian dude was a real POS. I agree. Yeah. He's very, very controlling. And the whole locking her out of the car and like people saw him putting his hands on. I wonder like how long that had been going on for, right? Like her family had no idea. Then the cops dropped the ball big time. Hey, Jahira, good to see you. Yeah. 𝐁𝐿𝐿𝐿𝐿𝐿𝐿, where you been? No worries. I am back. Don't worry no longer. I took the weekend off. I had a lot to get done and stuff to do. So I have a lot of cases that I'm going to be talking about. So I did a lot of that this weekend. But we can talk about that on a 𝗿𝐿𝐿𝐿𝐿 After Dark after this live. We're going to do a Wade Wilson 𝗿𝐿𝐿𝐿𝐿 After Dark after this. So I hope you guys can make it. He also went with her family to the spot where they found her. I know. And the little dirty Laundries are over there lying. You know what I mean? I'm shook that his mom was so willing to bury the body, right? You missed your Melly. I know I missed you guys too. Don't worry. This week, you guys are going to get sick of me. You're going to be like, we take that back. We're going to be doing a 𝗿𝐿𝐿𝐿 After Dark almost every night this week. It's going to get a little spicy up in there. It seems that it was an uphill battle for Gabby's mom and dad. Yeah, you know, this happens to their daughter. They were all friends. The search, her missing, the brutality of it. They didn't know. They relied on the police department. We know all about the police department. If you missed those lives, go watch how bad they failed Gabby. Yeah, I'm sad for them. And I think that they are really strong, but I also think that it must be hard to constantly hear about this, right? I can't even imagine if that was my kid, right? And then the parents found his body in a couple hours. Yeah. The parents were like, "Oh, we found it. It was luck." And we're like, "No, you knew where it was. Yeah, the search party couldn't find him for days. The police still. They did. They absolutely did. So we read the complaint, the Petitos against the Laundries first, and then we read their response, and now we're just going to get through this response from the Laundries back to, from the Petitos back to the Laundries. So they went back and forth for a little bit. Let me get a drink of water. It sucks. Okay, this isn't a very long document either. These are pretty short. So plaintiff's response to defendant's motion to dismiss the complaint. Joseph and Nicole Schmidt, Joseph Petito and Nicole Schmidt, instituted with an action by filing a complaint on March 10th. The complaint stated a claim based upon intentional infliction of emotional distress. The plaintiffs are the parents of Gabby Petito, deceased. Gabby was brutally unalived by the defendant's son, also deceased by parent unaliving. Plaintiff's complaint alleges that defendants were aware that Gabby Petito was deceased and were aware of the location of her lifeless body, and despite pleas from the plaintiffs, the defendants refused to provide any information to the plaintiffs regarding whether or not Gabby was still alive, and if she was not, where her body was located. Defendants filed a motion to dismiss the complaint on March 30th, 2022. The within response addresses the issues raised by the defendant's motion. A motion to dismiss is designed to test the legal sufficiency of the complaint. In determining the merits of a motion to dismiss, the trial court must limit itself to the four corners of the complaint. A complaint should not be dismissed for failure to state a cause of action unless it appears beyond doubtful that the plaintiff would prove no set of facts that would entitle him to relief. The function of a motion to dismiss is a complaint to raise a question of the law sufficiency of the facts alleged to state a cause of action. For the purpose of passing upon a motion to dismiss, the court must assume all facts alleged in the complaint to be true. Consequently, a motion to dismiss a complaint must be decided on questions of law and questions of law only. Defendants suggest in their motion that they assume the cause of action is one for intentional infliction of emotional distress, although the phrase intentional infliction, emotional distress does not appear in the complaint, and also suggests that it is possible that the plaintiffs might be trying to allege a cause of action for tortious interference with a dead body. Nowhere in the complaint is there any suggestion that the claim is based upon tortious interference with a body. There are no factual allegations regarding interference with a dead body, nor is there any claim for same. Simply because the words intentional infliction of emotional distress does not appear within the body of the complaint does not make the complaint defective. The elements of the claim are stated in the complaint. Defendants also suggest that the complaint is deficient because individual claims are not made on behalf of the plaintiffs against the defendants. Plaintiffs agree that the complaint should be amended to state such separate claims. To state the cause of action or intentional infliction of emotional distress, a complaint must allege, we already read this part, deliberate or reckless infliction of mental suffering, outrageous conduct, conduct was severe, and the distress was severe. To satisfy the first requirement of deliberate or reckless infliction or mental suffering, plaintiffs direct the court to the following paragraphs of the complaint. It is believed that on August 27, 2021, Brian Laundrie murdered Gabby Petito. The cause of her death was blunt force injuries to the head with manual strangulation. It is believed and therefore averred that on or about August 28, 2021, Brian advised his parents, Christopher and Roberta, that he had unalived Gabby. On that same date, Christopher and Roberta spoke with attorney Stephen Bertolino and sent him a retainer on September 2nd. After this point in time, there's no contact between Joseph Petito and Nicole on one hand and Christopher and Roberta on the other. On August 27th until September 19th, when Gabby's Petito remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabby. While Gabby's family was suffering, the Laundrie family went on vacation to Fort DeSoto Park on September 6th through the 7th. In an effort to avoid any contact with Nicole Schmidt, on or about September 10th, Roberta blocked her and her cellular phone such that neither phone calls nor texts could be delivered, and she blocked her on Facebook. On September 14, 2021, with full knowledge that Gabby Petito had been unalived by their son, Christopher and Roberta, through their lawyer, issued the family statement. The following statement. I think we read on this already. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. On September 16th, attorney Richard Stafford, on behalf of Gabby Petito's family, issued a letter to Christopher Laundrie and Roberta as follows. we read this letter at the beginning, right? We ask this letter to help you find our beautiful daughter. We understand you're going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of Brian and that Brian left Gabby. We beg you to tell us. Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, tell us where Gabby is located. All we want is for Gabby to come home. Despite the fact that Joseph and Nicole implored Christopher and Roberta to tell them if their daughter was alive and if she was not, where her remains were located, they refused to respond to either Joseph Petito or Nicole. Deliberate or reckless infliction of mental suffering on the part of the defendants involved their conduct in refusing to speak to the plaintiffs when they knew fully that Gabby had been unalived by their son and that they knew where the body was, that they deliberately took efforts to block the ability of the plaintiffs to contact them, that they went on vacation with their son who had unalived the plaintiff's daughter, while the plaintiffs were desperately seeking any information that they could find concerning the well-being and whereabouts of their daughter, and that they issued a statement through the lawyer that they hoped that the search for Miss Petito was successful and she was reunited with her family, all the time knowing that their son had unalived Gabby and hidden the body. Hey, Patty, good to see you. Melly reads so well. Melly, read me. Oh, you guys want a little bedtime story? Yeah, I guess he had been out there for a bit and Florida will rot a body quick. Yes, Loki. Vacation? That was no vacation, right? They were hiding the body. Yeah, this is just, we read the complaint and then we are reading the because they wanted to dismiss it. And so we're reading the response back. The referenced paragraphs of plaintiff's complaint sufficiently allege deliberate or reckless infliction of emotional distress. To satisfy the requirement that the conduct was outrageous, it must be so outrageous in character and so extreme in degree to go beyond all possible bounds of decency. And applying that standard, it is manifest that the subjective response of the person who is the target of the actor's conduct is not to control the question of whether the tort occurred. Rather, the evaluation of claimed misconduct must be taken to determine as objectively as is possible whether it is atrocious and utterly intolerable in a civilized community. The burden falls to the judiciary and is a matter of law, not a question of fact. At this stage of the proceedings, it is not the burden of the plaintiffs to prove the outrageousness of the conduct. Rather, the question is where there are sufficient facts pled and the allegations must be accepted as true. Based upon the paragraphs referenced in paragraph 11 above, plaintiffs submit that they have alleged conduct which is extreme and outrageous and goes beyond all possible bounds of decency. Can anyone truly suggest that it is not atrocious and utterly intolerable in a civilized community to refuse to tell grieving parents where their child's remains are located? That's a good question for you guys in the chat. Can anyone truly suggest that it is not atrocious and utterly intolerable in a civilized community to refuse to tell grieving parents where their child's remains are located? What would you do if you were in that position? I'm curious. Further, in support of the outrageousness requirement, unequal position of the parties in a relationship where one asserts and has the power to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. In this instance, the defendants clearly had the power to affect the interest of plaintiffs and that they knew that the plaintiffs were desperately searching for their daughter. Defendants knew where she was and refused to provide the information. In support of the third element of intentional infliction of emotional distress, requiring that the conduct caused emotional distress, paragraph 30 of plaintiff complaint reads as follows. Christopher and Roberta knew of the mental suffering and anguish of Joseph and Nicole. They knew that they could alleviate, at least in such part, such mental suffering and anguish by disclosing what they knew about the well-being and the location of the remains of Gabby, yet they repeatedly refused to do so. In doing so, the Laundries acted with malice or great indifference to the rights of Joseph and Nicole. This paragraph clearly states that the conduct of the defendants in not providing the requested information to the plaintiffs caused continuation of their distress and likely increased it. The defendants' suggestion that the conduct of the Laundries had to be the sole and proximate cause is without merit, and the defendants cite that this honorable court to no such authority for such proposition. Defendants incredulously suggest that the plaintiff's complaint does not allege, let alone factually support, that the emotional distress was severe. This is an ironic suggestion given that the defendant themselves experienced the same emotional distress when their son was missing. So did the Laundries know that he was going to take his life? I wonder. You only get a bedtime story if you're on your best behavior. Yeah. After this live, we'll hop into bedtime stories. You're funny. I hope you're moving the next ones. That's funny. Significant feelings of fright, shame, worry, and humiliation and others besides occasioned by the acts of others are, even if regrettable, to an unavoidable part of living in society. They're experienced by all of us. Complete emotional tranquility is a seldom attainable in this world, and some degree of transient and tribal emotional distress is part of the price of living among people. Paragraph 26 of plaintiff's complaint quotes a letter issued to the defendants in which plaintiffs state, "We ask you to put yourselves in our shoes. We haven't been able to sleep or eat, and our lives are falling apart. As the parent, how could you let us go through this pain and not help us?" Paragraph 32 of the complaint states as follows: "As a direct and proximate result of the willfulness and maliciousness of Christopher and Roberta, Joseph and Nicole have been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for the enjoyment of life, experienced in the past and to be experienced in the future." For the defendants to suggest that the plaintiff's grief and mental suffering was not severe is disingenuous and frankly disgusting. The case is not about fright, shame, worry, or humiliation, or transient or trivial emotional distress. Is there any greater horror for a parent than to lose contact with a child with whom they had daily contact, while the party with whom their child has been traveling returned home safe, and that child and his family refused to provide any information regarding plaintiff's missing child? The allegations of the complaint plainly and clearly describe severe distress experienced by the plaintiffs. I agree with the Petitos. That is straight bull. I believe the plan was to get Brian to some undisclosed location, but after not hearing from him, they must have known he self-deleted, and that is proven by how fast they found his body. And were they distraught? Like, did they care? Were they distraught about Gabby? Why not Gabby and their son? Like, a life is a life, right? I'm just a little confused why they're so sick in the head. I thought for a while that Brian is alive because of how some people think that. What did Lily say? You were right, there's no proof, but that letter from Roberta is quite telling. It is. Hello, beautiful Patty. Hello, my love. Good to see you. Context clues everywhere. Right. Brian and his dirty feet. Okay, let's get back to this. The defendants to suggest the plaintiff's grief. Oh yeah, I already read that part, my bad. Defendants correctly state that the conduct, which would otherwise be extreme and outrageous, may at times be privileged under the circumstance. However, defendants' suggestion that they were entitled to such privilege is wrong. Defendants wrongly suggest that in this instance, the First Amendment guarantees them the right to speak freely and the right to refrain from speaking at all. I'm not going to read that part. I don't want to hear about these. They're just going over like other cases. In this matter, there's no state action at issue, and the defendant's First Amendment rights are not implicated. While they may have chosen to say nothing, they have no constitutional right under the circumstances herein to remain silent. Defendants also seem to suggest that they had a Fifth Amendment constitutional right not to speak in the face of a criminal investigation. Defendants then go on to state there was unquestionably law enforcement investigation of the Laundries regarding the disappearance of Miss Petito. Defendants' arguments are premised on alleged facts which are not within the four corners of the complaint and therefore should be ignored. Likewise, defendants' argument regarding the right to speak to an attorney has no relevance to this matter. Defendants argue incorrectly that for conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and his or her presence. While such conduct, I'm going to skip that part too. In the within matter, plaintiffs have alleged that the conduct of the defendants was directed at them specifically, and they are not suggesting it was directed at a third person. Wherefore, all the reasons cited above, plaintiffs respectfully request that the Honorable Court enter an order as follows. Grant, in part, defendant's motion to dismiss based upon plaintiff's failure to assert separate claims on behalf of each plaintiff against each defendant and giving plaintiff 20 days to file an amended complaint, denying the remainder of the defendant's motion to dismiss. Yeah. And the letter Brian left talking about his parents had nothing to do with anything and had to leave them alone. Set up. Even the alligators don't like him. Yeah, I know. It was a month. Go on a family camping trip and nothing was even brought up, and Gabby not being there. And then going home with her van, and they're upset that the Petitos were questioning them. I don't get that. Even if you're trying to protect your son. I do think the Petitos were in the right. I think they're in the right all across the board. I think the Laundries are disgusting. And I think they should be arrested. Or at least should have done some time. I think his mom wrote the letter of confession. Yeah, I think so too. I think so too. That's sad. I still have yet to watch the documentary. I think I want to get through all the documents before I watch it. But that's all I have for you guys tonight regarding Gabby. We have another live. Hey, Mo! Mo, you made it. But hop in the next live. We're doing Wade Wilson in like 15 minutes. Yeah, we're doing a combo live after this. Yeah, that is a good thought, I'll say. They can be morally right and others can be trashed, but not sure they did anything illegal. Well, I agree, Loki Lopez. They ended up the Petitos didn't get what they wanted out of the lawsuit. So clearly the court did agree with the Laundries to an extent. They didn't do anything illegal. I mean, well, the hiding the body part and all of that, sure, but couldn't be proved. And then I don't know. They don't have to talk to police. That's true what it says in there, So they didn't do anything illegal, but when it comes to morals, sure, but that's not criminal. But I do think that they played a huge role in Gabby's disappearance. Kim Watts, good thing. Oh, yeah, I'm glad you made it. We just finished. We just read like 3 of the Gabby documents. The complaint, the motion to dismiss, and then their response back. Laundries back to Petitos, back to Laundries. Yeah. We're doing a Melly After Dark after this, and we're going to cover Wade Wilson. So if you guys are into that, I will see you in the next live. Thank you for being here. We'll be back with more Gabby Petito later this week. New cases, a collab coming. Collab we've all been waiting for. New case. We're going to deep dive a true crime case with a friend. So I'm excited about that. Yeah. Replay crew. Okay, cool. Yeah. If you can make it to the Wade Wilson, I will see you guys there. Yeah. My favorite. Wade. Make sure you hit the like button. If you guys can make it to the next live, I will see you there. A friend. Y'all are funny. We can talk more about that if you want. Deep dives. Yes. That is a crazy story. I don't. Y'all are giving me a hard time. I see you. That one is good. I actually should look into that, Mike. So thank you for recommending that. Yes, please. Not Wade. We're gonna incorporate Wade into the Melly After Dark tonight. Anyways, I'll see you guys there. Thank you for being here. But we love you. Yeah, I know. Meet me in the next live. I'll be live in like the next 15-20 minutes. So hop on there if you're gonna stay up. And thank you for being here. Make sure you hit the like button. Thank you for being here and listening to the Gabby documents. It's so important that we get all the facts. And we are for the Petito family here. So, which? Hi, which? hop on to the next live. I'll see you guys there. Thank you for being here, and make sure you hit that like button, and I always appreciate all the support. I'll see you on the next one.
Dark hair shining in the Cali sun. Really on the case, so no point in trying to run. The sun's can ask for feet pics, but you getting none. It's 𝗏 with Melly, let's have some fucking fun. Some try to hide away, so all they do is work. But nobody can hide once she gets a hold of that paperwork. So don't you dare come in here acting like a jerk. Dance might make her dance, but new court docs will make her wanna twerk. Dark hair shining in the Cali sun. Melly on the case, so no point in trying to run. You Sims can ask for feet pics, but you getting none. It's 𝗏 with Melly, let's have some fucking fun. So if you're feeling for true crime, like it's a drug, 𝗏 with Melly is your motherfucking plug. Going so hard on criminals, they'll call their mama for a hug. She's finding out all the stuff they try to sweep under the rug. Dark hair shining in the Cali sun. Melly on the case, so no point in trying to run. You Sims can ask for feet